Muy buenas tardes, les agradezco su presencia. Es para mí un honor presentar a la profesora Linda McLean, que nos va a hablar esta tarde sobre moral readings, originalism, and whether the Constitution is an empty cupboard of sex equality and marriage equality. Professor Linda McLean is Paul M. Siskin Research Scholar at Boston Law School, and her interests are in family law and policy, children and the law, gender and the law, feminist legal theory, civil society, political philosophy, reproductive issues, law and religion, religious liberty, equality, welfare law, comparative family law. She is known for her work in family law, gender and law, and feminist legal theory. Her scholarships addresses the respective roles of families, other institutions of civil society, and of government in fostering cities' capabilities for democratic and personal self-government. She has engaged with prominent communitarian, civic republican, and feminist critiques of liberal legal and political theory, and offered a reconstructive liberal feminist approach to such matters as privacy, family and marriage, reproductive issues, and welfare law. Her work also addresses sex equality and as a legal and constitutional commitment and public value, the responsibility of government to promote equality and societal tensions over equality and its relationships to other values. She has led organizer of the recent BU Law Conference evaluating claims about the end of men, legal and other perspectives. Since fall 2010, she has been a faculty fellow at the BU School of Theology, where she has pursued issues of pluralism, religion in the public square, and the role of religion in conflict and peacemaking. She contributes to the blog Balkanization and frequently speaks to the press on issues concerning family law and marriage. Her new book, Order, Liberty, Rights, Responsibilities, and Virtue, on Harvard University Press 2013, co-authored with James Fleming, develops and defends a civic and constitutional liberalism that takes responsibilities and virtues as well as rights seriously. So she will talk for about 30 minutes, and afterward Professor Fleming will do a reply for about 10 minutes. Please.
Okay, thank you very much. It's good to see you live versus virtual. Thank you, Emer, for organizing this conference. It's really exciting to see such an interest in constitutional interpretation. And since I'm not only a co-author and colleague of Jim Fleming, but also married to him, it would be a little awkward for me to get up here and do a devastating critique of his book. So I'm going to try to step back and say what's at stake here beyond labels in terms of a very pressing constitutional controversy in the United States right now about marriage, and also ask about what interest feminists have in whether we do moral readings or originalist readings. And my subtitle, the title of my paper, Moral Readings, Originalism, and Whether the Constitution is an Empty Cupboard for Sex Equality and Marriage Equality, for those of you who didn't immediately understand that reference, Ruth Bader Ginsburg, long before she joined the Supreme Court, observed that for a very long time in our constitutional history, the Constitution was read as basically an empty cupboard with respect to sex equality. Empty cupboard, nothing in it. It's very empty. All right? And it was only in the recent decades that the court finally kind of turned in how it read the Equal Protection Clause. Okay, so I'd like to talk a little bit as a way into this issue by focusing on the Sixth Circuit case that the Supreme Court decided to grant cert on, and that it will be hearing this term, and we can expect a decision by late June, DeBoer versus Snyder, because The significance of that case in terms of getting the court to take the case was it created what we call circuit split. The 4th, 7th, 9th, and 10th circuits had all affirmed federal district court rulings striking down state marriage bans that prohibited same-sex couples from marrying or allowed a state to refuse to recognize a valid out-of-state marriage. The 6th Circuit, by contrast, affirmed 4 state laws, both statutory law and constitutional amendments, in Michigan, Ohio, Tennessee, and Kentucky that either barred couples from marrying or barred recognition from marrying, and thus reversed lower court rulings, including in Michigan where there had been a lengthy trial on the idea of whether there was a rational basis or not for excluding same-sex couples from marriage. So what's interesting about the 6th Circuit case in terms of this conversation is that the majority opinion by Judge Sutton and the dissenting opinion by Judge Daughtry take sharply contrasting views of the relevance of original meaning with respect to the definition of marriage and the 14th Amendment. They differ about what the relevant constitutional test is for evaluating arguments by same-sex couples that their exclusion from civil marriage and state recognition offends the 14th Amendment. And they also take sharply contrasting approaches to marriage. Is it universal, unchanging? Our ancestors, most societies in the world, always had the same definition? Or is it an evolving institution, evolving in light of, among other things, constitutional norms of liberty and equality? So I'll ask if we see a contrast between an originalist and a moral reading of the right to marry or of the requirements of equal protection as they bear on marriage laws. Do we see conflicting views of original meaning, or to use the favored contemporary parlance, original public meaning? These are intriguing questions given the flurry of blog posts, initially in anticipation of U.S. versus Windsor 2 years ago, but now in anticipation of a ruling in DeBoer about whether or not there is an originalist case for same-sex marriage, and if so, what form the argument could or should take. Larry Solom has made a contribution to this, trying to get the term straight at least, frankly admitting he's not really sure if there's an originalist case, but the most promising avenue might be privileges and immunities. A number of other people have made arguments, and basically some have argued you could go the route of sex discrimination, right, like Steve Calabresi and Julia Rickert, and some have argued you could simply go the route of sexual orientation discrimination, in each case interpreting the 14th Amendment to bar to bar class-based or caste-based legislation, but arguing that the factual understanding of that time was mistaken about women, was mistaken about gays and lesbians, but if we can abstract that principle and apply it to a revived understanding of the factual situation, we can make these arguments. So, but before we get to that, I want to read, do people all have the paper, Emer? Or, I'm just going to share with you the language from the Sixth Circuit opinion. We've talked a lot about what is constitutional interpretation like. Is it different from other types of interpretation? Judge Sutton, here's what he says about original meaning. When two individuals sign a contract to sell a house, so that's the analogy, no one thinks that years down the road, one party of the contract may change the terms of the deal. That's why the parties put the agreement in writing and signed it publicly, to prevent changed perceptions and needs from changing the guarantees in the agreement. So it normally goes with the Constitution. The written charter cements, look at the building link, cements the limitations on government into an unbending bulwark, not like a weather vane, alterable whenever alterations occur, unless and until the people, like contracting parties, choose to change the contract through agreed-upon mechanism for doing so, namely Article 5. As applied here, this approach permits today's marriage laws to stand until the democratic processes say they should stand no more. From the founding of the Republic to 2003, every state defined marriage as a relationship between a man and a woman, meaning that the 14th Amendment permits but does not require states to define marriage in that way. Now, in this imagery, far from a construction zone or building out, we have a fixed cement gird. You can't touch it. This is what it is, okay? It's meant to prevent kind of altering. In dissent, Judge Daughtry says, the majority's original meaning analysis can tell us little about the 14th Amendment except to assure us that, quote, the people who adopted the 14th Amendment never understood it to require the states to change the definition of marriage, close quote. That's quoting the majority. The quick answer is that they undoubtedly did not understand that it would also require school desegregation in 1955 or the end of miscegenation laws across the country, beginning in California in 1948 and culminating in Loving versus Virginia in 1967. Moreover, there is not now and has never been a universally accepted definition of marriage. When Justice Alito noted in Windsor that the opponents of the Defense of Marriage Act were asking us to endorse a more expansive definition of marriage and reject the traditional view, he may have been unfamiliar with all that the traditional view entailed, especially for women subjected to coverture as a result of Anglo-American common law. 14th Amendment cases decided by the court since 1971, that's Reed versus Reed, that invalidated various laws and policies that categorized by sex have been part of a transformation that has altered the very the very institution at the heart of this case, marriage. So there you see a sharp contrast between two different views of marriage and two different approaches to original meaning. So it's very intriguing to me as a family law scholar and a gender and law or feminist legal scholar to think about these two approaches and then to consider what's going on right now in terms of trying to make an originalist argument that the 14th Amendment can support a case for same-sex marriage, either through the sex discrimination route or the sexual orientation route. Are these arguments better understood as Jim Fleming might contend as a form of moral reading under the mistaken label of originalism because they entail an appeal to an abstract moral principle of equality? Those who advance these arguments insist that original public meaning can be separated or abstracted from mistaken factual premises. As Ilya Somin argues, this permits an updating of the application of fixed principles, such as equality, in light of new factual information. Originalists, in the blogs, people make these arguments both about sex discrimination and about sexual orientation discrimination. I'm pretty confident, having read Jim's manuscript, or most of it, that he would argue that these originalists are engaging in methods formally criticized when used by moral readers. Cass Sunstein, for example, has recently contended that Calabresi's anti-caste argument is not easy to count as originalist, since it seems to be extracting from historical materials an abstract principle involving equality, giving that principle concrete and contested content, and then insisting on a long-standing social practice must fall because it's inconsistent with the principle. Sunstein says this necessarily depends on contemporary moral judgment, which is exactly what originalists seek to avoid. The appeal of originalism, he said, and what gives it a claim on our attention, is its efforts to keep judges from governing the rest of us according to their own moral judgments. He, of course, thinks that originalism should be rejected and the court should rule not based on original understanding, but based on building on the wisdom of the 21st century. Dale Carpenter has also recently argued that it would be very critical of Sutton's opinion. It would be very hard to justify most of the court's modern equal protection opinions under the type of analysis Sutton gives of original meaning, which he characterizes specific intention originalism versus principle-based originalism. So I'm not an expert on originalism. I'm not really going to try to rule on all of that. But getting back to Ginsburg and the empty cupboard, one of the things Calabresi is trying to write against is Justice Ginsburg's argument in 1979, long before she joined the court, when she was still a litigator, having litigated some of these path-breaking equal protection cases, quote, boldly dynamic interpretation, departing radically from original understanding, is required to tie to the 14th Amendment's Equal Protection Clause a command that government treat men and women as individuals equal in rights, responsibilities, and opportunities. And in that article and in other writing, she memorably observed that well into the 20th century, quote, our fundamental instrument of government, the Constitution, was thought an empty cupboard for sex equality claims. Only as the court started to shift with her pioneering litigation strategy of bringing carefully chosen test cases, did the court gradually move away from an interpretation, empty cupboard interpretation in a series of equal protection claims. Now, in terms of mistaken factual premises, while the court striking down a series of sex-based classifications premised on the old breadwinner, homemaker, master-dependent dichotomy inherent in separate spheres ideology was a significant shift in constitutional jurisprudence, feminist commentators, including Ginsburg, also pointed out that in effect the court was simply recognizing that the world had changed. And in rejecting sex-based classifications rooted in fixed notions about gender and outdated stereotypes, the court was catching up with dramatic societal transformation in the roles of women, particularly women's significant greater participation in the workforce. Now, not surprisingly, mindful of this history of empty cupboard jurisprudence and of constitutional interpretation, feminists have not generally been among the ranks of originalists. And I asked Larry Solm about this, and I think he agrees with me. He did suggest that if you have a progressive post-war constitution with robust sex equality clauses, then feminists may want to make originalist arguments to constrain more conservative jurists. But for the most part, you haven't found women jumping on the originalist bandwagon. And in an extremely witty essay by Marianne Case, the ladies, forget about them. A feminist perspective on the limits of originalism brought up the famous correspondence between Abigail Adams and John Adams, where in 1776 she asked John to remember the ladies and be more generous and favorable to them than your ancestors. And we can't really, we don't know the communicative content of what they meant when they wrote to each other, but his response to her was basically that we men know better than to, challenge our masculine systems. And you already have enough power, and if we relinquish this actual, this power we have, which isn't so great in fact as it is in theory, we'd be at the mercy of petticoat government, okay? So that's just a little moment in time, which helps to explain why feminists have never been on the bandwagon of originalism. We could fast forward 100 years to right around the time of the ratification of the 14th Amendment, and you have just a few years later the famous opinion or infamous opinion of Bradwell versus United States, where the court rejects the privileges and immunities argument of Myra Bradwell to be admitted to the practice of law in Illinois, and the concurring opinion by Justice Bradley makes the famous argument that women's destiny by the law of nature, the law of the creator, and the order of things is to be a wife and mother, her paramount destiny, and she's disabled from many occupations of civil life. And I was conferring with my daughter just before the conference because she's writing an essay about the Seneca Falls Declaration, 1848. They talk about the tyranny and unjust government of the family, right, due to laws of marriage. So we have plenty of moments in time where we could see that the order of things included a hierarchical order in the family. Therefore, when we get universalist appeals to what marriage has always been, and the unchanging understanding of marriage, there's two problems. First of all, to the extent we're looking at how the founders and then the framers understood marriage, it's riddled with sex inequality and hierarchy, which has by and large been repudiated by now. And in Casey, 1992, when the court strikes down the husband notification provision, the court observes the Constitution protects individuals, men and women alike, from unjustified state interference, even when it's enacted in the law for benefit of their spouses. There was a time not long ago when a different understanding of the family and of the Constitution prevailed. See Bradwell, right? And quotes that special language from Bradwell. The court says only, and this principle of the husband as being the head and representative of the social state flowed from the cardinal rule, of the sort of unity of husband and wife, that the wife had no separate legal existence. I don't know the law, the history in Mexico, but basically women's civil existence was suspended due to coverture, okay? And then the court says only one generation has passed since this court observed that woman is still regarded as the center of home and family life, with attendant special responsibilities that precluded full and independent legal status under the Constitution. Hoyt versus Florida, 1961. These views, of course, are no longer consistent with our understanding of the family, the individual, or the Constitution. A state may not give man dominion over his wife that parents exercise over their children. So feminist constitutional analysis, I suggest, is more likely to find common ground with moral readings than with originalism, to the extent that the former argue that the Constitution embodies abstract moral principles, but there's been a shortfall between constitutional ideals and historical practices, and those historical practices include constitutional interpretation. The definitional issue presented by the newer originalism is whether it's distancing itself from, by today's vantage point, flawed application of constitutional principles premised on faulty factual understanding is really a moral reading, or is simply the further evolution of originalism, in which case we're all in the same big tent. Doesn't matter what we call it. So I want to turn and think a little bit about the marriage issue, because it's a very intriguing case in point. As a family law scholar, I would never be on board with someone claiming we've had an unchanging, universal understanding of marriage going back to the founding, and even before that, as Justice Sutton says, throughout history, in virtually all societies, including our ancestors, is simply erroneous. As Posner pointed out very wittily in the Seventh Circuit, when the state attorney general appealed to the wonders of tradition, polygamy was far more common than monogamy, including at the time of the founding, right? Furthermore, as Chief Justice Marshall observed in Goodridge, in the first case in which a state Supreme Court successfully struck down a state law, and then the legislature enacted a same-sex marriage law, as a public institution and a right of fundamental importance, civil marriage is an evolving paradigm. This is the basic choice: evolving paradigm versus kind of fixed in time, universal understanding. The framers, the founders, the good people of America, the voters of Michigan, it's all the same thing, all right? The common law was exceptionally harsh toward women who became wives. A woman's legal identity all but evaporated into that of her husband. But at least since the middle of the 19th century, but incrementally, both the courts and the legislatures have acted to ameliorate the harshness of the common law regime. And then she goes on to say, alarms over the imminent erosion of the natural order of marriage were sounded over the demise of these developments and over the demise of anti-miscegenation laws. But marriage has survived all these transformations, and we have no doubt it can continue to be vibrant and revered. So the reference to anti-miscegenation is also very important, because as most of you who follow this debate knows, Loving versus Virginia has become an incredibly important precedent in this battle. In Windsor, I had thought that Romer was the most important part of the Windsor opinion, but I now believe that Loving is the most important part, because all these federal courts striking down state marriage laws keep saying that when Justice Kennedy says that, defining marriage is, of course, the province of the states, subject, of course, to the constitutional rights of persons, see Loving, then we all have to know, okay, what kind of limit does that put on state authority? But Loving also functions as a very real example of how historical understandings of what marriage was at the time of the ratification of the 14th Amendment aren't controlling of how we interpret the right to marry, because clearly many states had restrictions on interracial marriage, and many more states adopted them, and yet in Loving the court says we're not bound by the fact that some people arguing said it's not going to do anything about these bans on interracial marriage, and some said it should. That's not going to be the last word. And it's the same thing we see in Lawrence versus Texas, where the court says history and tradition alone is not enough. So these are all kind of movements away from any sort of settled understanding of what a term meant to people in a particular historical context. And in Jim's book, where he talks about Windsor and Romer and Lawrence, a very important passage in this sort of moral reading approach is what Justice Kennedy sounds in the closing lines of Lawrence. Had those who drew and ratified the Due Process Clause known the components of liberty in its manifold possibilities, they might have been more specific. They did not presume to have this insight. They knew times can blind us to certain truths, and later generations can see that laws once thought necessary and proper in fact serve only to oppress. And here's the kicker. As the Constitution endures, persons in every generation can evoke its principles in their own search for greater freedom. This is a big theme in Balkan's Redemption Project, right? And it's also a big theme in the marriage debates. Because if you believe that every generation, can kind of aspire to make the Constitution's promises, principles, their own, then it also applies very much in marriage. Am I doing on time?
It's fine.
I'm okay. Okay. So, this when you get back to how state courts and federal courts have resolved these challenges to marriage laws, first under state constitutions and then under federal constitution, you see this sort of tension between the argument that marriage is it's unchanging, it's timeless, versus it's an evolving institution. It's evolved in terms of sex discrimination, it's evolved in terms of race discrimination, anti-miscegenation laws. Now, and again, Kennedy's disclaimer in Loving has been quoted as a disclaimer of enormous proportion. But I'd like to say a little bit about how Judge Sutton understands the rationale for marriage, because it's actually curious that the responsible procreation argument that has been so pervasive in these arguments as a rational basis for state marriage laws, for those of you who have the pleasure of not being familiar with this argument, I'm going to share it with you in a nutshell. I've written about this in Cardozo Law Review in 2007, but it's been used many, many, many more times since then. Judge Sutton says, not only does the meaning of marriages between a man and woman date back to the founding, it dates back thousands of years. And voters in 2004, 1 year after Goodridge, were certainly entitled to stand by the traditional definition of marriage. How can we say that they acted irrationally for sticking with the seen benefits of thousands of years of adherence to the traditional definition of marriage in the face of 1 year of experience with the Duden definition? A Burkean sense of caution does not violate the 14th Amendment, least of all when measured by a timeline less than a dozen years long. So again, he says a dose of humility makes us hesitant to condemn as unconstitutionally irrational a view of marriage shared not long ago by every society in the world, shared by most, if not all, of our ancestors, and today by a significant number of the states. Now, I'm going to tell you about this argument. What's really interesting is this isn't actually a very good historical argument about the founding, and I'm going to talk about that in a minute. So the view of marriage is the by now familiar responsible procreation or channeling arguments. 4 other circuit courts have rejected this, with Posner saying it was so full of holes as to not be taken seriously. But the majority says government got into the marriage business and remains in it, not to regulate love. Surprise, it was Valentine's Day, you thought it was about love, you're wrong. But to regulate sex, most specifically the intended and unintended effects of male-female intercourse, getting very specific. And to ensure parental investment and commitment to the natural effects of male-female intercourse. Children. It's not society's laws, it's not any one religion's laws, it's nature's laws. That men and women complement each other, they fit together biologically, that creates a policy imperative for marriage. And governments shouldn't be second-guessed under the Constitution for prioritizing how they tackle these issues. Now, the template for this argument is really Justice Cordy's dissent in Goodridge. Cordy, drawing on James Q. Wilson, this is another paper I've written elsewhere, the marriage problem, identifies the evolutionary problem of sexual and reproductive asymmetry of men and women in the state of nature and the need for a mechanism to anchor men to women and to children. Without marriage, men stray. So it's a way of anchoring men and channeling responsibility. Now, I'm not going to critique this argument here, but it's interesting to see that Sutton thinks that that's what it meant, that's what states have been doing, that's what the voters thought they were doing, and we're not going to second guess it. And as is typical of this type of static view of marriage, it's not Lawrence or Loving, it's Washington versus Glucksberg that features in support of the import of original meaning in these legal debates. Now, Daughtry, in dissent, identifies various problems with original meaning. For starters, that polygamous marriages outnumber monogamous ones even today, but also the incredible change over time of what marriage meant in the U.S. But what's really interesting to me is that if you really want to look back and see what marriage meant at the founding, this is brought out in the dissent and in the trial itself. The founders had a political theory about marriage, and Nancy Cott has documented this beautifully in her book, Public Vows. Political theory of marriage was that it was a metaphor for consent of by the governed. The wife freely consented to the husband's rule, and kind of paradoxically, her final act as an agent with contractual capacity was to consent to marriage, and then she lost her contractual capacity. But this was a metaphor for political self-government. But as Kerber and Cott elaborate, marriage performed important gender work, because in it, wives gentled men and taught them manners. And manners in the 18th century had a lot deeper meaning than it has today. All of this gender work went on within the marital household. As Dirk Hartog elaborates, in ruling his household, the husband's capacity for citizenship expanded. He governed, he represented, he possessed. Okay? This has nothing to do with channeling accidental pregnancy. This has to do with the conception of political order, the household and order, and the political order being the household writ large. Okay? So basically, this is just a small original meaning point. But the point is, it wasn't about channeling irresponsible reproduction. It was a whole picture of gender. So then the sex discrimination argument for marriage equality, which I think feminists would support, Calabresi and Rickert do this as well, is that the entire edifice of domestic relations law rested on gender hierarchy. And then in the 19th century, it's kind of softened a bit to talk about separate spheres, gender complementarity, and gender ordering. A combination of state law reform and constitutional litigation have brought a dismantling of nearly all of that edifice. But the one man, one woman definition, one may plausibly argue, is a vestige of coverture because it relates to the different complementary roles or offices that husbands and wives were to perform as head of the household and family, an obedient, independent femme couvert, the covered woman under the protection of the man. To return to my opening question, which I didn't actually say, sorry, what's in a name or why do definitions matter? The question is really, when all of this has changed, what rational basis remains for the one man, one woman definition? And the accidental pregnancy argument is something they came up with because after Lawrence, they can't say preserving morality, right? That's what the DOMA report said. But that was right after the court decides Romer, and the Justice Department assured Congress, no problem, go ahead, no constitutional problems, all right? So they as opposers said they want to make moral arguments, but they know there's some constitutional problems. So instead we have these very creative arguments about channeling, and gay people can't have children by accident, they're rational planners, they don't need the stabilizing effects of marriage, but those reckless heterosexuals need it, and that's why this institution that in Griswold, noble, intimate to the degree of being sacred, is kind of debased to being kind of the shotgun wedding, So that's kind of what we have. Anyway, so to wrap up then, it's very intriguing and worth noting when prominent originalist theorists wish to champion prohibiting sex discrimination as a proper aim of the 14th Amendment. And it's also intriguing, as the court considers De Boer, to read about some attempts under the umbrella of originalism to make a constitutional case for same-sex marriage based on how a proper understanding of either sex discrimination or the anti-caste principle supports such an outcome. What strikes me, though, is this theme of generational progress. I read the language from Lawrence. Now, in Windsor, what's very striking is that Kennedy does a 1-2. Lawrence gets you to respect for the dignity of intimate association between gay men or lesbians, but it's the state of New York that confers the dignity of the institution of marriage. And New York gets through an evolutionary process. So the moral understanding comes through the deliberative process at the state level, not through a court. And what's also interesting about about Windsor, getting back to narrative, is the narrative that Edith Windsor longed to marry, aspired to marriage. You know, citizens longed to formalize their relationship. But the people of New York, many didn't, they understood marriage in this traditional way. They couldn't imagine it this other way. But gradually, they come to a new understanding. It's a way of seeing differently. To go back to Lawrence, later generations can see that laws once thought necessary and proper, in fact, serve only to oppress. So too, the people of New York, through a deliberative process, come to see that this is an injustice. Now, what does all this portend for what the court will do in June in DeBoer? I don't really know. But the generational progress theme, I think, is very, very critically important. Dale Carpenter and Bill Eskridge have pointed out it's unimaginable in 1868 that you could have told people gay and lesbian parents are just as capable as heterosexual parents. It's probably unimaginable you could have said it in 1968. But now, the facts, the understanding of facts has really changed. So even Judge Sutton, in saying this is really for the people to decide, Constitution doesn't say anything about it, Sutton says gay parents are just as capable of heterosexual parents. No one's talking about their parenthood. No one's talking about their ability to make a commitment. This is a major change from Romer and the incredible type of things that were said in support of Colorado's anti-gay initiative, you know, where they're talking about predators and everything else. So I'm out of time, right? Yeah. Okay, I'm out of time. So thank you very much. Okay, and now I'll listen to Jim's response to that brutal critique. Okay.
Well, that was wonderful, and I rest my case. Because this was an example I gave in the opening chapter about the struggle within the new generation of originalists to find a way to save. Oh, sorry. Thank you. As I said, I rest my case. This is a great illustration of generational change and the struggle with young originalists to find a way to say that originalism gets you to same-sex marriage, but the only way they can say that is by renouncing everything originalism has ever stood for and by using all of the rhetoric of moral reading, living constitutionalism, generational change, and the like. I think that hearing you give the paper makes me wish I'd done a whole chapter on this in the book.
It's not too late.
Because it is a great illustration of.
So Jim submitted this manuscript before the court granted cert
right.
in this case.
It's a great encapsulation of many of the points that I make at various points in the book. But I want to turn it over to discussion.
I'm not keeping the cue.
We can up to discussion.
Well, I think that the debate between Judges Sutton and Daugherty, is it Daugherty or
Daughtry?
Daughtry.
Yeah.
Okay. I think that's an excellent illustration of the uphill battle that the therapeutic originalists, like Larry, face. Judge Sutton says of the Constitution that, first of all, he calls it a contract. He likens it to Magna Carta. He says that the contract was designed to limit government. He didn't get any of this from the history of the American founding. It is true that occasionally the word social contract is used, for example, in the Federalist Papers, but it is also perfectly clear from the overall thrust of the Federalist Papers and from the language of the Constitution itself that the Constitution was seen and debated as essentially an enabling act, and that the test of the Constitution was not whether it protected rights per se, but whether it achieved what Hamilton calls in the First Federalist the dignity, security, and happiness of the American people. So here's a case of an originalist judge who cites founding material and yet gets it entirely wrong. Now, even if I'm wrong about Judge Sutton's understanding of the Constitution. The very least that one could say is that Judge Sutton's understanding of original material is highly controversial, and therefore that an interpreter like us would have to make a moral choice, a choice based on some kind of moral theory, about which interpretation of the founding is or might be the best.
Yes, another question back there.
I think Larry had his hand. Well,
okay,
I mean,
or
I guess
can
the only
we
thing
accumulate, or
well,
do you
I
want
think
to-
the only thing I would say about that is there's another important piece I should mention because it helps to sort of put this all in some context. You know, what judges who rule against the same-sex couples tend to say about loving is that loving is distinguishable because no one questioned the one man, one woman definition, and loving stresses the procreative importance of marriage, right? So there's a way of kind of making space for loving without, I mean, because in all of these opinions there's a sort of, it's a level of generality problem. Is it a fundamental right to marry at a broad right, or is it a narrow right? And so the people trying to argue against, the public officials arguing against recognition of same-sex marriage go Glucksberg, and the people arguing in favor of broad right go Loving, go Zablocki, go Turner versus Safley, which for those of you who don't know all these precedents, you know Loving is about striking down Virginia's interracial ban. Zablocki is where the state of Wisconsin says if you're a deadbeat dad and you can't pay your child support, you can't marry until you can show that you can pay your child support. And when you do pay your child support, your child won't be a ward of the state. And then Turner is about prisoner marriage. So they say it wasn't a narrow right of prisoners to marry or a narrow right of deadbeat dads to marry. It was a general right to marry. So there's a battle over how you define the right. And this is another part of the interpretive battle that's going on.
Thank you.
Yeah, I have. First, let me say I'm on board with everything that you've said. The point I'm going to make is a minor point, but I want to say a little something about how important this issue is to me. I bend gender norms. I like to wear eyeliner and flashy jackets, and I was assaulted 6 months ago by two guys who ran up behind me, and, well, they figured out they might have picked the wrong guy to assault. So I mean, I'm appalled listening to, you know, some of these case decisions. I mean, I can barely contain myself. This really upsets me. So I'm on board with everything that you say, but there was one little thing that I'd like to address about the moral reading being better able to ground marriage equality. There are two forms of it, and there's an objective form where the morality that you're looking at is objective morality, mind-independent morality, and then there's a form of it that looks at conventional morality. I take Justice Brennan's Evolving Standards of Decency to exemplify the latter. Now, I don't know how that fits with popular constitutionalism. I don't trust popular constitutionalism just because of how it sounds, right? I don't like to leave stuff to the people to decide on because they might decide on the basis of piecemeal views and not like theory. But here's the epistemic problem with the objectivist moral reading, and that's my theory. No one has privileged access to objective morality. You know, you could take a guy like Scalia, and if he adopted a moral reading, he could justify all his holdings on the basis of an objectivist moral reading because no one's got privileged access. These folks actually believe that the things that they're doing by way of oppressing gays and lesbians and transgender community is objectively okay from a moral point of view. But now, from the conventionalist moral reading, you get a different result right away. Brennan's view was that you decide these issues by looking to evolving standards of decency, and that's conventional morality. And I got to say, you know, look, I don't trust conventional morality either, because that can go against people as well. I mean, at one point, conventional morality thought slavery was okay. But here's the point about today. We just checked. 37 states have marriage equality. We win in the fight. The dinosaurs, they're going to go extinct. So I just wanted to point out that there's a difference here. You got to worry about the objectivist moral reading because, again, no one has privileged access to the facts about morality on a moral objectivist view. But coming at it from a conventionalist moral reading, game over. Game's over. So this is less a question than it is a comment on a very, very minor point. And I got to say, keep on fighting the fight because you're fighting a good fight. God bless you. That's all I can.
Thank you. Well, but of those 37 states, quite a few, it's a result of the Supreme Court denying cert in these circuit court rulings. So in New York, I think why Kennedy could write that Windsor opinion the way he wrote it is he could cloak himself in New York's evolving understanding and deliberative process. Had he taken the Massachusetts case, I don't know how he would have written the opinion, right? Because Massachusetts, it comes through, of course, the constitutional decision-making is part of state processes, but it doesn't have the same valence as the people of New York through a deliberative process. So part of the backlash problem right now is even if the Supreme Court rules in favor of marriage equality, more than half the states in the nation have no protection for gays and lesbians and LGBT people under state anti-discrimination laws. So you're going to get all sorts of situations about, where you don't have robust protection against discrimination, but you have the right to marry. If you can find a clerk willing to perform the ceremony, issue a license, if you can find a magistrate willing to marry you, and if you can find a hall willing to rent you a facility. So anyway, but in terms of truth, I don't know. This is kind of a little bit outside of the battles over originalism. But one strand of objection to same-sex marriage is that it's contrary to the truth of what marriage is. This is the Robbie George, Ryan Anderson, Sharif Gurgis argument that they made in amicus briefs, and that Justice Alito, when he says this is a battle between two models of marriage, conjugal marriage and consent-based marriage. Some people give kind of a responsible procreation type argument for conjugal marriage. Some people get to a deeper philosophical argument. And he cites George, Sharif, and Gurgis's book, What is Marriage? Man, Woman, a Defense. So there are people out there who believe there is an objective truth about what marriage is, and they claim they're not relying on God, but in other writing they really do. So I don't know. That is a kind of, and that may be why we're having states try to pass laws now refusing to issue marriage licenses. Some of it's a state sovereignty argument. Some of it is a truth of marriage that is contrary to what the secular authorities purport to do now. And it's a showdown over a true understanding of marriage. This is way out of the bounds of originals. This is like the truth about marriage, right?
Could I hazard then just one more very, very brief comment? A lot of people think that intellectual property shouldn't be protected by law because, well, the concept of property applies only to material things. When it comes to the law, it seems to me, okay, I don't care what you call it. What matters is the bundle of rights that are protected. So, my argument, I've written on the legitimacy of intellectual property protection, and my argument is this. My response to the people who say it ain't property is, I don't care about that. I care, you can call these rights then something else if you want to. All I care about is the bundle of rights and the ability to exclude people from content that I create. You don't want to call it property? Cool, that's fine. The law shouldn't be bound by these kinds of definitions. It doesn't matter what you call them, right? Now, when it comes to sacramental marriage, that's a different story. I can't tell no church what to do, and I have no... I can't say I don't have any desire to do it, but it's absolutely futile to do it. So I would make kind of the same move. I understand that the word marriage has a certain content that suggests legitimization of a relationship and that maybe domestic unions don't. But I think the most important thing here is the content of the right and not so much what we call it. And the sort of argument I make with respect to skeptics about whether there exists intellectual property, I would make with respect to skeptics about marriage when it comes to legal marriage. I don't know whose hand was up. I thought Ken's was first. So,
there's another question over here, please. Yes, you. Yeah, please.
Who's taking?
Yes, you. Yeah, thank you.
So I next.
You are next?
No, he's been his head up a long time.
Okay. I saw him first, but go. Yeah.
Okay. Well, this is kind of echoing in this context Sat's earlier comment about responsibility and originalism. And it seems to me the way that you describe Sutton's argument, I mean, Sutton purports to be doing originalism, but he's actually engaged in a moral reading. And it's a moral reading that is based on traditionalist Catholic theology. And which is what Robbie George is it's traditionalist. Well, you can tell me.
I don't think Robbie
disagree.
makes a responsible procreation argument.
Well, I've heard him make it in. I don't know whether I don't read much of
Okay.
him, but I know personally that he's said it. I've heard him make that argument verbally. But he certainly is a subscriber to traditionalist Catholic theology, and you know, it tends to be those very, very principled, systematic arguments about the role, complementarity and all that kind of thing, at least. Yeah. But going back, you know, it doesn't have to be Catholic theology, although that's certainly ascendant, traditionalist Catholic theology. But in U.S. history, I mean, it really is, to say something for Judge Sutton, you know, polygamy may be the most common, may have been and may still be the most common form of marriage in the world, but certainly the U.S., to the extent it was a Protestant Christian nation, was always never imagined these alternative forms of marriage, and that's evident in things like Reynolds, where they openly talk about Christian peoples and things like that. And so it doesn't have to be Catholic, but that actually is both a religious argument and a traditionalist argument, rather than a more Catholic. Catholic argument tends to be more philosophical, so I'm just wondering how it may be a little outside the paper, but these arguments, I guess the larger point is, you know, just as people said this about laissez-faire infecting in Herbert Spencer's social statics, right? Underlying theories about social theories, moral theories, cultural worldviews will inform people's understandings of the law, and that's happening with originalism as it happened to anything else. So I'm just, if you have any comment.
So the thing about polygamy, my point there is that he doesn't simply say from the founding of the Republic or at the time of the framing, because certainly we had this incredible battle against polygamy. He says throughout universally for millennia in virtually every society. So that's the part that Posner goes after in the Seventh Circuit opinion, and that's the part that Doherty is going after. It's like when you broaden it to say it's just universally understood that that's what marriage is. Now, the only thing I want to say about Robbie George for anyone who's interested in these intricate distinctions, the Robbie George argument is that there's a teleology of marriage. It's a little bit like what Hadley Arcus said in the congressional report for DOMA. There's the male and female, there's the body parts, there's the sealing, the S-E-A-L-I-N-G, the sealing of the bodies in one flesh union that is open to procreation. He doesn't, I mean, I think strategically they'll make the responsible procreation argument, just like throw that one on the pile. But the deeper argument they want to make is if you reason about what marriage is, you would understand that there's these bodies, they have a purpose, they fit together a certain way, there's a deeper union. Gay people can't achieve that, and they can't produce children, and this is the sort of telos. These are the debates Steve Macedo had back in the 80s with, what's his name, Curtis Bradley, over sodomy laws, like, Gerard Bradley. Right, I mean, it was like there's the telos, there's the body, you know, John Finnis. I mean, this is the kind of thing. They weren't really talking so much about accidental procreation. That's a you know, another variant of the same types of concerns about why it's about the sexes. And then I guess the only other thing about the moral reading is there is a kind of theme in Sutton's opinion that isn't it a shame that you guys couldn't do this through the democratic process? It's better. It's the right way to do this. And maybe this is a moral view. The right way to do this is to win a victory in the legislature, to persuade the good people of Michigan to overturn their ballot initiative, to overturn their amendment. Aren't you being cheated you lesbian couple, when you had to get to a court to get this outcome? Wouldn't you feel better about yourselves, and wouldn't we all feel better as a society if we could get this through convince the people? So that's kind of the argument about it. But the reason he can do this, he claims the Constitution doesn't require a different outcome. I mean, Larry Solom's been waiting to speak for like...
No, go right ahead, son.
There's another question.
Larry's on the line, but he has another here.
Okay.
Thank you for the paper, Linda. Really a wonderful paper. Just a couple of tiny things, right? One is just Sutton really is an illustration of a problem for originalism. And a lot of people are thinking about this problem, which is that judges, for the most part, even judges who might think they want to be originalism, know very little about it, right? They just don't have exposure to originalist theory. And Sutton, I think, is a good example of this. This would not be an opinion you would hope, that someone who had been trained at some point exposed fully to the theory would write. Just another point, which is that from an originalist perspective, I don't think the original meaning of marriage is at issue here, right? Marriage isn't in the Constitution. There is no marriage clause. Sutton may have thought that this was relevant, but it's not necessarily relevant at all from an originalist perspective. Okay, those two little things out of the way. Bradwell, right? So the argument for Bradwell was an originalist argument. The term originalism did not exist, right? But the argument was that under the Privileges or Immunities Clause, right, anything that was a privilege or immunity was extended to all citizens of the United States. And it's clear that women were citizens, right? There was no, that was absolutely uncontroversial at the time. So the only question then was whether or not the right to occupy a normal profession, to pursue a trade or profession, was a privilege or immunity of citizens of the United States. Now, I do not know the answer to that question, right? I think it's a difficult question, but there was a lot of evidence that from the public debates that the right to pursue a trade or profession was in the bundle of rights that were considered privileges or immunities of the United States. So whether the argument worked or not, that was the argument that the plaintiffs made. The argument on the other side was a moral readings argument, right? It had two aspects. One aspect had to do with the best conception of federalism. So the Supreme Court that essentially nullified the Privileges or Immunities Clause in the Slaughterhouse cases and Bradwell and Cruikshank thought that adopting the reading of the Privileges or Immunities Clause that was expected by the people who participated in the public debates and the ratification process in the debates in Congress, right, which were public debates, unlike the Philadelphia Convention, that understanding of how much power Congress would have was just inconsistent with the best theory of federalism. They thought it was just inconceivable that we would do what the public meaning of the clause seemed to require. And so instead they adopted a theory of the Privileges or Immunities Clause that just is sort of crazy, right? They say that the privileges or immunities of citizens of the United States are things like the privilege or immunity of being protected by the United States Navy on the high seas against pirates. Like Louisiana is going to send the Louisiana Navy to help the pirates and interfere with protection by the United States Navy or the right to go to an American embassy abroad. Like the state of Mississippi is somehow going to interpose itself between citizens and the American embassy in Paris. Right? Just a ludicrous interpretation of what the content was, an interpretation that essentially nullifies it, reduces it to a set that's so small that it had no implication. The second piece of reasoning in Bradwell is also a moral reading, right, based on a moral understanding of the proper role of women. This is sort of no accident. There was a lot of wrangling, you probably know this, about the wording of the 14th Amendment. Women wanted the 14th Amendment to include provisions that were not included. They weren't able to get that. But Section 1 does not say men. It doesn't say the privileges or immunities of men. It doesn't say equal protection for men. It doesn't say due process for men, right? And that created a plain meaning argument for results that might not have been endorsed sort of on a case-by-case basis, but that might follow fairly directly from the original meaning. So I guess I just want to say that is there anything in the cupboard, right? Is there anything in the cupboard? Right. Well, that depends on your historical situation, right, and on what the original meaning of the provision was. Certainly after Bradwell, there wasn't much in the cupboard of the 14th Amendment. But Bradwell was not an originalist decision. An originalist decision might you have to really know what the Privileges or Immunities Clause meant, and I sure don't. I've read a bunch of books about it. I have friends who work on it, but I haven't read the original sources. I don't really know what it means. But if there was an argument in Bradwell, it was privileges or immunities. And just to attach this to same-sex marriage, if there's an argument about same-sex marriage on originalist grounds, I don't think it's to be found in the Equal Protection Clause. It's probably to be found in the Privileges or Immunities Clause. Hasn't been much work on it. Very difficult argument to make to the Supreme Court right now because only Justice Thomas will listen to that argument, right? Justice Scalia and the other conservatives have rejected any attempt to revive the original meaning of the Privileges or Immunities Clause. Shameful from the point of view of many originalists, right? This is the McDonald case is sort of, very dispirited. Only Thomas will go with original meaning.
I think that's really interesting what you pointed out about Bradwell, because certainly, the female justices of the Supreme Court from time to time will make speeches. And I don't know about Kagan and Sotomayor, but O'Connor, Ginsburg, and they'll often talk about the sort of sad history of constitutional interpretation. And Bradwell is almost always quoted, the language, that passage about women's destiny. So it's very interesting in terms of that. Larry, one other thing I'm puzzled about, when you say that the original meaning of marriage isn't really at issue, when you make arguments about the fundamental right to marry, kind of the due process side of these arguments, there's all sorts of debate over how to understand the right to marry and whether it is, a broad right that could encompass same-sex couples, or whether it was never intended to include same-sex couples. And the reason Loving comes up, of course, is the state of Virginia says there's no way that the ratifiers thought that the 14th and 15th Amendment was going to have any impact on interracial marriage bans, right? And the court says we're not bound by what various people said about this issue. So I thought that how you interpret the right to marry is a matter of interpretation and does go to, how you understand the right to marry. I thought it was an interpretive battle, and some people are appealing to what marriage has always meant since the founding, right? Like when Congress was debating the federal marriage amendment, right? You had Mitt Romney stand up and say Mitt Romney was the governor of Massachusetts and he had lived through, was he still governor when the Goodrich came down? He had lived through the Supreme Court of Massachusetts saying that the Massachusetts Constitution required same-sex couples to marry, and he went into Congress and said, we need a federal marriage amendment, because that's the only way to stop these activist judges. And he said, will we, I'm not going to get it right, will we depart from marriage as the founders have known it, as the founders knew it? I mean, it was what marriage meant was at stake. So I'm kind of puzzled by why you think it has nothing to do with what marriage means or what marriage has meant.
Well, just really super briefly,
Yes,
right?
because
It
there's
would be relevant for some kinds of substantive due process analysis, right? But that we don't even go there. You know, originalists don't believe there is any substantive due process,
Okay.
right? Or, for the most part. So it's the terms of the debate are so changed from contemporary doctrinal terms. And I can imagine possible arguments about the nature of marriage being relevant to original meaning in some contexts, but it's certainly not going to be because we have to figure out the original public meaning of the marriage clause of the Constitution, because obviously there is and never has been such a clause.
Yes, please. Another question over there.
Thank you. Good afternoon. In Mexico, most of our marriage jurisprudence remote to the neo-Romanistic system and to the Code of Napoleon, etc. And I think there's no trouble in trying to investigate the origin of marriage. It's more like a originalistic argument in Mexico rather than a moral reading. So, and for example, the root of the word marriage comes from mother and from this idea of one man, one woman, actual procreation. My question would be, what's your take on creating a new figure in order to conduct the feelings that these homosexual couples are having? Call it love, call it whatever you want. What's your take on creating a new figure here in Mexico, for example, or in the United States, different than marriage?
You mean a new status?
Yeah, new status, a new law figure.
Well, you know, what happened in the United States is a remedy that Vermont chose was to create a civil union based on, like, what some European nations had. And then some other states adopted civil unions instead of marriage, with all the legal consequences of marriage, but not the name of marriage. But what happened is California's Supreme Court ruled that it offended the California Constitution to give same-sex couples something called the domestic partnership and not marriage. It offended equal dignity and respect. So the kind of experiment of calling it something else sort of ran up against two things: constitutional rulings that it offended equal dignity and respect, and empirical studies by task forces or commissions that found that in theory you were supposed to have equality, but in reality people didn't understand what a civil union was. Hospital administrators wouldn't admit a civil union partner to a hospital room. You know, medical personnel wouldn't recognize a person as a parent because they were civil union partner, and so they weren't actually getting equality. So some LGBT theorists in the U.S. thought it would be great to have these alternative statuses, to like be free of the label marriage. But two things, I think gay community leaders said, no, we have to have marriage because only marriage will do. Constitutional courts bought that argument. And meanwhile, practical on-the-ground experience suggested that it's not that easy to have a status that actually gets the treatment you're expecting to get. So if we were writing on a clean slate, maybe what's really interesting in the United States is that Illinois and Hawaii now have same-sex marriage, but they kept their civil union laws. And those laws are open to opposite-sex couples as well. So those are states in which gay couples and straight couples can enter into a civil union or enter into a marriage. They can choose. Nevada has domestic partnership open to opposite-sex couples and same-sex couples. Now, you don't get any of the federal benefits of marriage, but you do get anything you get under state law.
Is there another question? Because is this about the same point? Or can... Okay.
I guess my response would be get rid of the term marriage in all law and call it all domestic unions or domestic partnerships.
Right.
I mean, I'd be fine with that. I mean, I really don't care what you call it. I care about the bundle of rights. So let's just get out of the law, out the marriage game, and put them in everybody in the domestic partnership game and be done with this silliness.
Well, that would be quite a result after all this arguing about the expressive value of marriage.
No, I see that.
Only marriage will do.
Yeah, well, not for me.
Right. No, it's a great point, and certainly scholars have made this argument. You should disestablish marriage, call it something else, get the state out of the marriage business. Call it civil unions, call it civil partnerships, call it something different. Which would address the civil marriage, religious marriage line that gets so complicated when religious people feel so deeply offended that their conception of marriage is being, in their view, denied by the state somehow.
Just in closing,
Larry, you should say one thing about that. Apart from the fact that marriage isn't going to be disestablished, in some ways, had we gone that radical route, it would have given substance to an argument that seems without substance, and that is that same-sex marriage is going to degrade marriage. And so if society had responded by saying the only way we can adjust to this is to create a civil status that isn't marriage for anyone, I think it would have been a profound concession. Now, the circumstances are very different, but one of the most precocious moral things ever said by a justice, which we could ask whether he was appealing to any original understanding at all, is Justice Harlan in Plessy v. Ferguson, when he said of a separate but equal situation, which really was rather separate but equal. There were just railroad cars, and you had black attendants in black cars and white attendants in white cars. And what Harlan said was there's only one meaning to this law. And what he meant was there was only one social meaning to this law. And I think denying marriage to same-sex couples, there's only one meaning to it. It's the last vestige of intentionally withholding dignity, I think, in some powerful way.
In the New Jersey constitutional litigation, the New Jersey court ruled that under the New Jersey Constitution, couples in New Jersey had to have access to the rights of marriage, but not the rights to marriage. And they said, hey, give civil unions a chance. I mean, give these labels a chance to catch on. You may think it's demeaning. You may think it's not equal, but how do you know? It just started. Give it a chance. So it's a little bit like, the opposite of, and then a few years later, you've got state constitutional Supreme Court saying it's clear it's not equal, right? And Posner says that in the Seventh Circuit about the domestic partnership laws, by the way. And of course, Harlan and Plessy is a building block to Romer, and Romer is a building block to Windsor, and it may prove to be a building block in whatever the court does in June.
I have a small question as well. I mean, if these people that speaks about gender complementarity as from a moral perspective, the Catholic one, for instance, even when it's secular, I mean, it seems that the analysis, even from moral reading or from an originalism reading, would be flawed, no? Because, I mean, they cannot really pin out clearly what is the harm of allowing same-sex marriage. So I would say, no, that the limitation of liberty is what is at stake, and you can see, I mean, how to defend the rights of people to marriage, even when even when it cannot be seen from an originalist point of view clearly, what is the interpretation, the best interpretation that one can do out of our rights. But I fear that, I mean, this ontological status of gender complementarity, I mean, I don't see the way to solve it or to sort it out even from these two perspectives. So I'm wondering, because I'm dealing with the same kind of arguments in my thesis, so I'm kind of wondering what would you say or how to respond to them. What is the best way from one or to the other bias to respond to these kind of arguments about, I mean,
Yeah, you know,
ontological content.
Right. I think courts have gone two directions on this. Some courts say, even accepting the premise that marriage has this purpose of channeling heterosexuals who otherwise might not marry, how does excluding gay couples advance that purpose? Is it really the case that they'll be less likely to marry if they know that gay couples can marry? And so courts that have taken that approach have fairly easily said, you can't show that excluding same-sex couples furthers this channeling. If anything, it would be in the state's interest to stabilize all family units. And, you know, gay couples rearing children could also benefit. The other approach is say the state doesn't have to show that, all they have to show is it's rational to give these benefits to heterosexuals.
Exactly.
You know, so it really, and it also depends on the standard review, how relaxed the standard review is. You know, like in New York in Hernandez versus Robles, highly indulgent deferential review, they just said, look, it's just rational because these people are, you know, accidental pregnancy types. The gay people are rational planners. They don't need the stability as much as these reckless people do. But the idea is, how is it that same-sex couples being allowed to marry will further the channeling or harm the channeling function? So, I mean, I guess you're saying just take it as a given that there's some argument here about getting the sexes to stabilize themselves. It's not clear that you can only achieve that. But what the comeback typically is, people like Maggie Gallagher and the National Organization for Marriage is, you sever the link between marriage and procreation. In people's minds, marriage no longer is about procreation and parenthood. It's severed. And so if gay people can marry, it's like the last straw argument. It's the last thing that moves us away from marriage as a committed, stable, heterosexual union about procreation. Right? Right.
Not about children's well-being, because otherwise they would promote some others' policies to protect children's well-being instead of preventing people to have same-sex marriage, right?
Well, and that's the other thing, is that as Posner pointed out, you know, the way we secure parental investment in children is also through child support laws and paternity laws. We don't rely exclusively on marriage to anchor child well-being. And furthermore, as Posner pointed out, because gay couples are adopting children, right, it's irrational to exclude them. If you think children do better with marital families, then it's irrational to exclude them. And in fact, Kennedy, you know, what really comes out in Windsor is the humiliation of children when their parents' marriage is not treated as an equal marriage to other marriages. Posner takes the same language, and it could be that if the Supreme Court rules in favor of these couples, it'll be the humiliation of children argument, which is ironic, or maybe that's not the right word of irony, because, you know, we've somehow morphed from this argument about equality and dignity and whatever to saying, and particularly the impact on children. We went from thinking gay people are a threat to children, like in Colorado, they're molesters, to thinking they're stable parents, they're just as capable, and you're humiliating their children to exclude them from the institution of marriage. So it would be interesting if that's the narrative thread of the Supreme, because the couple in DeBoer, lesbian foster parents, special needs children, my God, heroics, self-sacrifice, you know, and the state is thwarting them and hindering them from giving their family stability. And doesn't that sound like anti-family values, really?
Exactly.
Yeah.
Okay. Thank you very much.